I'm shooting a special extra video because California has irritated me because I looked through their brief and I caught something that I think may be lying by omission. I'm not saying they've done anything wrong, but I have to tell you, I'm not satisfied or happy with what they've argued in terms of machine guns and common use. Stay tuned. I'll break it down why I'm concerned when we get back. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and yes, New York Times best-selling author. If you have not subscribed to the Four Boxes Diner Second Amendment channel, please do so and show your love for the right to keep and bear arms. We're desperately trying to get to 100,000 subscribers. It'll make a big difference for us with the algorithm going forward. All right, I'm going to make this quick. I'm really irritated. I actually, as I told you, skimmed through the Bonta, the Duncan versus Bonta magazine ban case that is pending before Judge Benitez, it turns out. And I did through, and one thing that really turned me off and irritated me entirely is footnote number 11 from California's, I think their supplemental brief they submitted in November. And what irritated me is I think they're playing games. In fact, I know they're playing some sort of games here, and I'm going to tell you why. So in their footnote number 11, California is trying to argue that to demonstrate that standard capacity magazines that hold more than 10 rounds are in common use in America, you can't just look at the total numbers. Now, this is not true because if you look at Heller, they said handguns were commonly possessed by Americans for lawful purposes. They didn't take any discovery. They didn't need any experts. They just kind of like, yeah, it's a no-brainer. And Caetano, in 2016, the Supreme Court said that stun guns were commonly possessed by Americans for lawful purposes. And Justice Alito talked about 200,000 stun guns being commonly possessed. No breakdown of make or model or whether they were even fired. The fact that 200,000 Americans owned stun guns in 2016 made them commonly possessed. And as you know, once an arm is commonly possessed in the United States, it is considered protected under the Second Amendment. It is, in fact, protected under the Second Amendment. It cannot be banned. That's in juxtaposition, if you will, the historical standard that says that the American government may ban what would be considered dangerous and unusual weapons, which are relatively infrequent and rare. But one thing that dangerous and unusual weapons, without getting into the breakdown of that analysis, what the Supreme Court has said clearly in Heller and beyond is that what is absolutely 100% not a dangerous and unusual weapon that can be banned by any government agency in the United States are those arms that are commonly possessed by Americans for lawful purposes, which is no-brainer. Handguns, long guns, semi-automatic rifles like AR-15, semi-automatic rifles like AK-47 style firearms, and of course pistols and magazines and the things that go along with that. Okay, so what is the anti-gunners trying to do here? So in footnote 11, California is trying to get around and destroy the common use test to make it either unworkable or to try to make it so complicated it imposes tremendous cost on the pro-Second Amendment side. And the way they're trying to do this, and they're making this argument, here's how they make it. You got to stick with me for just a second here. It's not that hard, but you got to stick with me just for a second. They are arguing that Caetano talked about 200,000 stun guns being commonly possessed. That is a very low number, in my opinion, and a very good number for the pro-Second Amendment group, because now you only have to show that there's more than 200,000 arms of a particular type or class, and it's protected under the Second Amendment. And we know that there's hundreds of millions of magazines in the United States that hold more than 10 rounds. Obviously, that's a bigger number than 200,000. And we know there's tens of millions of semi-automatic rifles that are AR pattern or AK pattern firearms. And that, of course, is much larger than 200,000 stun guns in Caetano. So the anti-gunners have to somehow destroy, make unworkable, get rid of the common use test, the common possession test, because it's so good for the Second Amendment, as well it should be, because it's a textual fundamental right. But they're trying to destroy it. And how are they doing it? So here is how they've done it. But they've done it, in my view, in a very slippery way. Here's what they say. They say that the 200,000 figure in Caetano cannot possibly be the threshold above which all arms are commonly possessed and thus protected under the Second Amendment. And here's their argument. You'll see what they've done here. California argues, quote, this court, meaning Judge Benitez, I believe, in California, this court has stated that the Supreme Court implied that 200,000 stun guns were sufficient to show, quote, common ownership and receive constitutional protection, period, close quote. Citing to the Miller case, and the Miller case in California that was cited to Caetano and Alito, right? Okay. But then California goes on to say, this is the key, but that figure cannot be sufficient. California says that 200,000 stun gun figure cannot be sufficient. And here's where the curveball comes. The game comes from California. California then says there are more than 700,000 machine guns registered in the United States. There are more than 700,000 machine guns registered in the United States. They then cite to some ATF data. And they since the enactment of the NFA in 1934, machine guns have been heavily regulated, so on, so on, so on. So here's their fundamental point. They say, even though there are more registered machine guns than their number of stun guns discussed in Justice Alito's concurrence in Caetano, the Supreme Court has indicated that machine guns are not protected by the Second Amendment because they are not in common use. Accordingly, California argues numbers alone are not the driving force behind the court's determination that certain weapons are or are not protected by the Second Amendment, are or are not protected. So you see what's going on here is what they're trying to say is our side is arguing the 200,000, any type of firearm or class of firearm that has more than 200,000, as per Caetano, is commonly possessed and thus protected under the Second Amendment. It cannot be banned. That includes magazines, and that includes AR-15s and AK-47 style semi-automatic rifles, right? Game over, we win. So what they're trying to say is, no, that cannot be the test. It has to be something more complicated, more expensive, more difficult to figure out than just counting up the number of firearms or arms or magazines in America. It's more than that, and we know it's more than that, according to California, because there's 700,000 machine guns in the United States that we know of, and that is bigger than 200,000, and yet that 700,000 machine guns are not protected arms, according to what the Supreme Court has said, right? You understand the logic? They're saying that it can't be 200,000 because 700,000 machine guns are not protected, and that's bigger than 200,000, and therefore the common use test that's good for the Second Amendment community is not the right test. We have to do something more complicated, more expensive, more crazy. BS. That's total BS. You know why that's BS? And let me tell you what irritated me about this. Do you know how they got that 700,000? I actually looked at what they cited to. I actually spent time and actually drilled down the rabbit hole and looked at it. And I looked at their annual statistical update from the ATF that they cited to. And I looked to see where they got that 700,000 number. And this is where they got it from. This is where they got it from on page 16. Then I took a look carefully and I says, this can't be right. And then I realized the game. The game is this. You see, under the National Firearms Act of 1934, not only are privately owned machine guns that you could own or I could own, not only are they counted, but every single automatic weapon held by, let's say, a gun manufacturer that makes that makes machine guns for the military, or every single machine gun automatic weapon owned by, let's say, the NYPD or government, state or local governments like the New York Police Department or the Boston Police Department, they have automatic weapons, and those automatic weapons are registered, and therefore they are part of all those government-owned firearms, as well as all those government-owned automatic weapons, as well as those automatic weapons owned by like large manufacturing companies that supply machine guns to the government for defense purposes. Those all are counted in this 700,000 machine gun in America number, according to the ATF. But you see, California doesn't break down how many guns are actually in private civilian hands, which is what we're talking about when we're talking about common possession of Americans for lawful purposes. We're not talking about government-owned weapons. We're talking about privately owned weapons. Well, I then took a look, and guess what? I found, because of a citation and something that went into a Fifth Circuit Court of Appeals case called Hollis versus Lynch, a 2016 case that looked at the number of firearms, automatic firearms, actual machine guns owned and possessed by common, ordinary Americans. Not the government, not NYPD, not state police, none of that. And how many machine guns were owned when this case was decided in 2016 and by private individuals, which is the proper apple-to-apple comparison to Caetano and not apples to oranges. The answer is, according to the ATF and the Fifth Circuit Court of Appeals, 175,977 machine guns existed in private civilian hands from the 1986 Hughes Amendment ban. So you see what happened here? So in California's brief, they're talking about 700,000 machine guns is bigger than 200,000 stun guns in Caetano, and therefore the Caetano common possession test is unworkable. You can't use a judge. That's California's argument. But when you actually break down and you look carefully at what's going on here and the game that was played, it turns out that they conveniently, don't know. I mean, I can't see any evidence that they did this. Maybe it's somewhere in the thousands of pages that submitted, but I don't see anything obvious where they literally said, by the way, Judge Benitez, that 700,000 machine gun number, that includes all the machine guns owned by all these government agencies, all the state police around the country, by all the manufacturers that have contracts with the federal government to make machine guns, to sell them to the military. All those things are NFA items that you need a stamp for. No, they didn't break it down for Judge Benitez. They said, no, there's 700,000 registered machine guns, and they cite to an ATF document, conveniently ignoring the critical fact that when you break it down and you compare apples to apples, meaning the number of civilian-owned stun guns in Caetano in the Supreme Court's case in 2016 at 200,000, and then you compare it to the number of privately owned machine guns that were around before the 1986 Hughes Amendments, and that number is lower than the 200,000 Caetano number at 176,000, you see the game that they just played? They tried to argue to Benitez that 700,000 trumps 200,000, and therefore the 200,000 floor of protected arms in the United States is not workable. But they don't break it down the way they do to compare private civilian ownership of machine guns, which is less than 200,000, with a 200,000 floor number from stun guns in Caetano. So again, I was shocked that California in that footnote 11 did not break it down and disclose the details of what they should have disclosed and broke it down the right way. I don't know why. Maybe they didn't know, or maybe they knew and they didn't want to say, or maybe they figured the other side would have to catch it. Who knows? But whatever it is, I was very surprised that when I read footnote 11 of that brief, that they did not break it down to show and help out Judge Benitez to compare apples to apples or oranges to oranges, as opposed to apples to oranges, which is what I think they're doing when you compare 700,000 number, which includes government-owned machine guns, with just privately owned civilian stun guns in Caetano. Okay, I know this is a little bit geeky, a little bit broken down, but I thought this is important. I wanted to sort of teach you how to think about some of these things and just so you can see what some of these sort of pro-gun control legal briefs are doing, because you got to look very carefully at every single ampersand, comma, and semicolon to make sure they're not trying to take away our fundamental rights under the Second Amendment. I hope you learned something here today. I hope you enjoyed it. If you haven't subscribed, please do so, and we'll see you again soon here at the Four Boxes Diner.
Orders up. Table 2A.